Hi guys, welcome back to my channel. So in today's video, I'll be picking up from where I stopped in my previous video on the sources of Nigerian law. Yeah, and in today I'm going to be starting from the judicial precedent. So the judicial precedent refers to a decision of a court that establishes a principle of law. Under this part, we're just saying that courts follow the decisions that has been made before time, the judgment that the court has passed down before time in that similar matter. So it's more or less like saying that they should apply the principle of stare decisis, meaning they should stand by what has been decided and not to unsettle what has been established. So it's just like saying that the past judgment on similar matter, they should just follow that past judgment on similar matter. So under that judicial precedent, we talk about ratio descendi and obiter dictum. Ratio descendi is just talking about the rationale behind a decision, like the material fact behind which the court made that decision. You get what was the rationale behind it, and obiter dictum is just the remaining part of that decision. It doesn't necessarily affect, or will I say, it's not much of concern. So under judicial precedent, the basic thing we look out for that the court used to, will I say, follow this principle is the ratio descendi, I mean to say. Now, speaking of which, we have different type of precedents. We have the original precedent, binding precedent, persuasive precedent. Now, when the case is when let's say for instance we are talking about a land matter, yeah, and in that land matter someone trespass and the court is about to sit on that case. What the court will do on that instance is that if that matter is the first of its kind, yeah, after when they have judged that matter, the decision of the court become an original precedent, right? But then if there have been formal judgment that have been passed on that same similar matter, yeah, the court can refer to that judgment and look at the ratio descendendi of that matter, that is the material fact of that matter, and check it to see, okay, fine, it has been presided over before, we could adopt it in this same matter just so it saves time. Yeah, and when when that when a court, for instance, let's say for instance we have the state high court judging matters to defense, for instance, and the federal high court have judged similar matter on that same defense, the same similarities, it could just pick, sorry, let me correct myself there. Under the binding precedent, we have, we have hierarchy of courts, for instance, and in the hierarchy of courts we know that state high courts um and federal high court are actually of coordinate jurisdiction. So that will not be a better example. The better example here should be, let's say for instance we have state high court and magistrate court. Now state high court has given a judgment over a similar case. It becomes binding, that judgment becomes binding for a lower court like magistrate court to follow. You understand? So it's more or less like between two courts, one supreme, one superior, one lower. You get? So it's just like in a family now, the father gives a judgment. Yeah. When the son wants to attend to something similar, instead of giving his own judgment, he refer back to his what his father has said before and follow suit in that judgment. Therefore, the decision he will take is because of the father's former decision, and that his father's former decision is binding on him. So the next is persuasive precedent. Now this is the example I wanted to paint before, between federal high court and state high court. Now when courts of coordinate jurisdiction are are like when they are courts of coordinate jurisdiction, for instance federal high court and state high court, and there is a similar matter, yeah, and state high court have presided over that matter, yeah, before now. So let's say federal high court wants to now do similar case, the same matter but different parties. You get? What they just do is they are not bind, like the decision of the state high court is not binding on federal high court to follow. They could just decide to use it You get, they could just decide to pick up similar um, things that the state high court had earlier used in presiding over that matter, and they could adopt it. But it's not like they are compelled to do it. No, they're not compelled to do it. They're only persuaded to just do it. The lawyer, the counsel, can actually refer the court to look at a matter that has been presided over before, and he will now plead for the court to adopt same judgment that has been carried out in that matter, in that matter over the same case. So it's more or less like persuading the court to follow um the matter. Now, there are terminologies we find in judicial precedents. We talk about distinguishing. Distinguishing is just method of the court in a way to when, like, let's say for instance the judge adopts to avoid, he don't want to follow the same, decision that has been carried out before. He wants to look at the facts very well. Maybe let's say for instance the facts are not enough, or they are not sufficient for him to follow. So he looks at it very well. That kind of thing is called distinguishing. It's like he's checking to see if truly what has been decided before, like if it reflects the matter that is on hand now. So it's more or less like it's not like he wants to follow exactly, but he wants to confirm if it's follow. That is distinguish. He's trying to distinguish the matter between then and now. Yeah, if it's sufficiently and materially enough. Another one is overruling. Overruling is like nullifying what has been decided over before and bringing up a new rule, a new judgment. You get. Another one is reversing. Let's say for instance in hierarchy of courts now, the federal high court gives a judgment. The Supreme Court can actually reverse that judgment. You understand? So it's one of the terminologies of precedence. Another one is par incuriam. Par incuriam is when the court has made a judgment, when it has been spotted that that judgment was made in error or mistake. You get. So they could overrule that judgment, and yeah, when they could overrule that judgment. So that is it. Another one is moving on to the advantages and disadvantages. Like I mentioned earlier, it saves time. You get, it saves time, and someone can actually know the let's say punishment or the law that governs a subject matter because of the precedents now, what has been judged over time. You could know how in that same subject matter how the law can affect him or affect her. You get. So, and there are also disadvantages of it. We find out that it leads to lack of initiatives. Yeah, lack of initiative, especially when a lower court has to follow what judges has said over time. He will not be able to bring up his own ideas in most cases. You get. And then it makes law rigid. Yeah, it makes it not flexible, that they will follow a particular form or template or decision most of the time. Like when it comes to binding precedent, like it makes it rigid for the lower court to actually bring up their own initiative to make things flexible. You get. So there are other disadvantages again, which leads to slow development of the legal system. You get. So um that for the judicial precedent. So we'll move on to and there are also there are also there's also one source of law, which is the international law. Now these are laws that applies to Nigeria, right? There are laws that applies to Nigeria. We're going to looking at the classification of courts. So like I mentioned earlier, um we we I said something something similar to superior court and lower court. Yeah, and now we are going to be looking at the hierarchy of court. In the hierarchy of court in Nigeria, we know the Supreme Court is the first. Yeah, it's the first. It can actually overrule any judgment that has been made by a lower court. It's supreme. It's supreme. From the word supreme, you should know what it means. Then the next is the Court of Appeal, following next to it. We also have the Federal High Court. Yeah, and the Federal High Court deal with matters relating to revenue, taxation, bankruptcy, aviation, safety of aircraft, and the rest of it. And also, we also have the State High Court, Sharia Court of Appeal, Customary Court of Appeal, National Industrial Court. Now, let me pause here to say that Federal High Court, State High Court, National Industrial Court Customary Court of Appeal, Sharia courts are of coordinate jurisdiction, so they are operating under the same level. You get, they are operating under the same level, whereas magistrate courts, district courts, yeah, customary courts, these courts are of the same jurisdiction also. They are of the same jurisdiction also. Yeah. So we'll be moving on to the legislative process. Now, under legislative process, we know that um, like in a democratic government, when we're actually looking at the legislative arm of government, we're always hearing bill, 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 bill. You get, so there's always an introduction of bill in the houses, either in the National Assembly or in the Senate or House of um uh, that is the Senate, I mean to say, and the House of Rep. Now, what is a bill? A bill is a proposal that is intended to become law if it is duly passed. So it's the intention of a bill is just so it becomes a law when it is eventually passed. And we have public bill or private bill. But public bill has to do with bills that reflect education, health, housing, and so on. While private bill are bills that has to do with the interest of a group, region, or profession. So and there are different stages of a bill because before it becomes a law. We have the first reading, which is the first stage. Now, in this stage, we just this stage outlines the main aim of that bill. So the main aim of the bill are read out in this stage, and there's no discussion or whatsoever. No decision will be made on it, just to know the main aim of it. The second stage is talking about, is going to outline the main principle behind the bill. Yeah, that is when the house will debate about the principle behind the bill. And the committee stage, which is the next stage, is going to look at the clause of the bill. You understand, they will detailedly look at it, the clause of the bill. And the report stage is also the next stage after it. And in this third stage, this is where they take the final look at the bill and then do a vote on it, pass their vote to it. So when the house are satisfied with it, they send it to the president for him to give his own assent to the bill. Now we'll find out that there are division of legislative powers between the federal government and state government. So in as much as we also have the three arm of government, yeah, and in another three arm of government, we also know that in the legislative arm of it, we also, there are matters that the National Assembly preside alone, the State Assembly preside alone, and the House of Assembly preside alone. So um, for instance, now we have the exclusive legislative list, which is just is under this list. It only contains matters which the National Assembly alone can actually preside over. Include defense, security, immigration, and the rest of its kind. Yeah. So concurrent lists are matters that jointly the National Assembly and the State House of Assembly can actually make laws side by side. You get, so that is for the concurrent list where we have the education, housing, taxation, and the rest of it. While residual list is just for the House of Assembly of a state, and this has to do with chieftaincy matters, market administration, and so on. Now, I'm going to quickly look at the distinctions between criminal law and civil law. Yeah. First off, we must know that criminal law, let me say, the main persons or the main parties in criminal law has to do with the states and the accused person. So, and under this heading of criminal law, we find out that it's a law that creates offenses. It creates the offenses, and then there are punishments for those offenses. Yeah, so while in civil law, you find out that civil law just find way to protect the interest of people or protect the interest of citizens in their day-to-day activities. So let's begin. The criminal law creates offenses just as said here, while civil law, on the other hand, guards the rights and interests of citizens. The purpose of criminal law is the punishment of an offender, while the civil law is just to compensate the aggrieved person by way of damages. You're right. So in criminal law, for you to win the case, you must prove beyond reasonable doubt, while in civil law, you must tender evidence or balance of probabilities. So in criminal law, so there's no limitation of time during which a defendant could be prosecuted, but this is not so for the civil law, because you just have between 6 to 12 years, after which the case will be statute bad. Right. So um, I'm going to move straight to the governing principle of the Nigerian Data Protection Regulation. Now you find out that the major the major governing principle falls to, that is the way I actually decoded them. It falls to confidentiality, availability, integrity, yeah, storage, accuracy of data in an adequate manner. This is the way I actually decoded it, just so for the sake of the ICAN exams. The information must be accurate, the information should be adequate for what you're doing, and when you've collected those information, the confidentiality of that information should be at your fingertips. You have a duty of care over it, yeah. And for the sake of in um for the sake of availability, the information should be available when needed, yeah. And storage, it depends on how you save it. You should be accountable for how you store it, yeah. So that is how I decoded it to answering any question that comes on it. So let's go to the multi-choice question, yeah, for chapter 1. um they say appeal lies from the court of appeal in Nigeria too. Okay, it's just like saying which place can we actually make an appeal to. So like, let's say for instance, you go to court of appeal, and then you don't get the judgment you need. Where else can you go? The right answer there is the Supreme Court. Yeah, the Supreme Court is where you go, because that's now the next hierarchy over court of appeal. The next question is, Nigerian constitution is said to be rigid because the answer to it is C. It's rigid because it is in writing. Yeah, when it is in writing, it's more or less not that easy to amend. So the next one is, the following courts are of coordinate jurisdiction except. So the answer to this here um is the court of appeal. The court of appeal, yeah, the court of appeal is of no jurisdiction. It's not of the same jurisdiction with the rest of the courts stated there. Yeah, and the method of or principle by which a lower court may refuse to follow a decision of a superior court is known as. The answer there is distinguishing. Yeah. The government that may make laws on a concurrent list is or are. In this answer is the federal and state. Yeah. So open-ended question, state 5 maxims of equity. We know the 5 maxims of equity that, as mentioned in my first video, are um, um, equality is equity. If you must come to equity, you must come with a clean hands. He who seeks equity must do equity. Where equity are where equity are equal, the first in time prevails. Equity follows the law. Delay defeats equity. So these are the different maxims of equity. Okay, now the people of Eleko community have followed for a long time a custom. Yeah, when you read this down, you find out that okay, let's continue. Long time following a custom that makes it a taboo for a woman to give birth to twins. Such twins are killed, and in 2006 the community passed a law abolishing this practice. Thereafter, IJAF start gave birth to a set of twins in the community, and the elders of the community insist on killing the twins. IJAF Fisat is resisting. I should advise IJAF Fisat. Now, under this matter, you find out that it's a customary case here, and under this customary case, we should know that since we were made to understand that there was a custom long ago to kill twins, but that custom was abolished. Like, there was a law now in place abolishing that law. But then after the law has been in place, IJA officers gave birth to twins, and the elders of the community are insisting on killing the twins. What should IJA officer do? um IJA officers should hold on to the principle that there is a law in place. Let me explain. There are validity for customary laws, There's the repugnancy test, there's the culpability test, and also the public policy test. Now you find out that um, this, what the words of the elders are saying on killing the twins, it is incompatible with the law in place in that community. There's already a law that that has um, ended the killing of twins. Yeah. So IJA IJA officer to should hold on to that law. You should hold on to that law in court and she'll win the case. So also you say differentiate between ratio decidendi and obiter dictum. Like I said it before, ratio decidendi talks about the rationale behind a court's judgment, a court's formal decision, while obiter dictum are just looking at the other parts of um the 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 precedent. Ratio decidendi also not just looking at it from being the material fact, it is binding. Yeah, it is binding, that these are the facts that are binding for a court to follow. But obitaditum are not binding at all, they are just other things that the court maybe said in the course of that matter. So it's more or less like binding, they just, it could just be words that was said in that matter. So it's not like it's binding at all. Okay. So um I think we're going to stop here for today. Yeah, thank you so much for going with me in this journey. Yeah, please, this is actually my first chapter, and it's in business law. The aim of what I'm doing here is to um summarize what I was able to read every, like every day. I give a summary of what I read and I try to explain it as much as I can, because I believe that this video will be helpful to one person, one way or the other. And it's a journey that I'm actually taking towards my ICAN exams, which will be in May 2024. So I'll be dropping more videos on business law. Yeah, so I would want you, in the next video we're going to be talking about partnership and floating a company and all that. So if you like the video or you want to support in what I'm doing, to just say hey, continue, to just encourage me, you could please like my video, subscribe, yeah, and turn on the notification bell so you know when next I drop my video. Thank you so much.